Right, okay. So today we're going to talk about electronic tagging and reporting conditions. What are they and how to support individuals with bail conditions? My name is Brian. I'm the legal organizer at Migrants Organize. So we're a charity based in London, but we work kind of throughout the country, and I'm an immigration advisor accredited by the OIC. So as you all hopefully know, the seminar is part of a wider training series that we're organizing under the Solidarity Knows No Borders movement network. And we've got more than 20 online seminars throughout March and June covering different aspects of the hostile environment policy. So I'm hoping a lot of people here have already attended some other seminars in the series, or planning, have registered for others as well in the future. And please do help spread the word about the seminars to colleagues, friends, families. Everyone is welcome. Bail condition, what is it? So bail condition essentially refers to a condition that is imposed by the Home Office for an individual with insecure immigration status. So I'm talking about individuals who are still going through the process of regularizing their asylum, their immigration status, for example. This includes asylum seekers, individuals with pending applications, or simply individuals who have overstayed their visa and just kind of in the process of figuring out what to do. The source of the power to put someone on bail condition lies in the Immigration Act 2016, but it's helpful to know that, it's important to note that restrictions on migrants and asylum seekers have existed since, as far back as the Immigration Act 1971, where the Home Secretary was granted power as well by Parliament to impose restrictions on migrants and asylum seekers. So this is certainly not kind of a new concept, but the modern kind of iteration of it lies in Immigration Act 2016. Now, one thing that a lot of people don't understand, including the Home Office actually, is that the legislation itself, Immigration Act 2016, doesn't provide any preference in terms of which bail condition to impose someone. If someone is liable to be imposed a bail condition, then the Home Secretary, i.e. the Home Office, does have a duty to impose at least one condition, but that is all that the legislation say. It doesn't really specify which bail condition exactly needs to be imposed. So if you look through the Immigration Act 2016, Schedule 10, it gives example of reporting condition, detention, so immigration detention is part of it, residency condition, electronic tagging condition, which we'll talk about more today as well, no study condition, and importantly, any other condition the Secretary of State deems appropriate, which means there's actually quite a lot of leeway here for the Home Office to be quite creative in what they impose to migrants and asylum seekers. Unfortunately, reporting conditions seems to be kind of the main preferred condition for the Home Office. So in 2019, we did a Freedom of Information request to the Home Office, which revealed that 76.4% of all migrants in the UK who are on bail are given a reporting condition. So for some reason, it just ended up being kind of the go-to condition that Home Office caseworkers impose on migrants and asylum seekers, even though Freedom of Information data also confirms that only 2.7% of people released from detention absconded in 2021. Sorry, that's a mistake there in the slides. And absconding rate, I think in 2018 was only 3%, and it went down to 1% in 2020, if I remember. So really, really kind of not a lot of people basically abscond when they're already in the system. But despite this, a lot of migrants, as I said, are put on bail conditions, being asked to report, to go to the Home Office centers every week, sometimes every day, to kind of sign. And you can see that a news article I put there, during COVID lockdown, the Home Office even asked asylum seekers to come and report still during a period where everyone was supposed to kind of stay inside due to the pandemic. Now, recently, the Home Office has also introduced not introduced, but expanded on the use of electronic tagging. So that's a picture of the electronic tag. It's the same as the one that is used in the criminal justice system. Essentially, they've put in force Schedule 10, Part 1, Paragraph 2.2 and 2.3 of the Immigration Act 2016, where the Home Secretary now has the duty to electronically monitor all the subjects, like everyone who's been released on immigration bail on or after 31st of August 2021, who's counted as a foreign national offenders, i.e. individuals with criminal offense and criminal records. So individuals who are on bail will be given what's called a Bail 201 form, and it looks like this. So it has a picture on it, details of the person, and also if you see at the bottom there, they will kind of provide the reason why the person is on bail. And if you flip the page, usually then it will kind of show the conditions that the person is given by the Home Office. So in this case, for example, the person is given 3 conditions, but if we remember, the duty is actually to impose 1 condition. And reporting condition, again, it will look like that. You must report at an immigration official, or it will kind of provide the details of the reporting center where the person has to go to. And it will also provide the details of when and where. So it will say maybe once a day, every 1 week, every 2 weeks, every month, whatever that might be. And if you see at the bottom there, failure to comply with conditions, if you are asked to report and you fail to report, you will be counted as an absconder, and it will have impact on the immigration application. So especially if you have a human rights application pending, for example, it might mean that the Home Office then regard you as not suitable to be granted leave to remain in the UK. Likewise with asylum, I think it's much rarer for someone to be refused asylum on the basis of absconding or not complying with reporting condition, but it certainly counts, you know, as in the kind of the process, it counts against a person, and it might kind of basically make the person's case to stay in the UK weaker. Now, in this seminar, I'm going to talk about electronic monitoring, but more in the community context, so people who are already in the community who are provided bail. Bail for immigration detainees are actually going to do a seminar specifically on detention and the process of bail, so getting out of detention. So I would suggest that you register for that one if you want to hear more about how it works when someone has been through the immigration detention system. It's on the 22nd of June. So reporting and electronic tagging as well obviously have a lot of detrimental impact for individuals affected. So there's been quite a few reports on this actually. Migrants Organized produced one in 2020, and there's a lot of case studies identifying the different issues that might pop up because of reporting conditions. So when individuals go report, a lot of the times, especially before COVID, a lot of the times they have to travel really far distance. So in London, there used to be only 3 reporting centers, for example, one in London Bridge, which is the most central, another one in Croydon and in Hounslow. I had a client who was living in Camden, for example, but for some reason being asked to report in Hounslow. So using the tube and the train, it took him about an hour and a half just to go to a reporting center. He had to queue 2 hours outside of the reporting center just to sign, and then another journey back an hour and a half. So if you think about it, it was really a whole day affair for him. And the situation is even worse, obviously, outside of London, where there's less reporting center. So individuals, asylum seekers on Stoke-on-Trent, for example, I think was asked to report at Dallas Court in Manchester, which required them to use like 3 different public transport, and it was a 3 hours journey one way and back. And there's, especially if you think about, you know, individuals with mental health disabilities or physical health disabilities, the entire process can be really, really stressful. And a lot of individuals actually kind of get really stressed out and their health deteriorate as a result of reporting. especially if you think about how constant it is and how long someone can be put on a reporting condition. You know, we're not talking about someone being asked to go to the Home Office every, you know, just for 6 months or a year, for example. Some people can be on reporting conditions for years on end. So while waiting for their asylum claim to be decided, they might be put on a reporting condition, which means they have to go to the Home Office every week for 5 years or 6 years. We've certainly had cases like that at Migrants Organized, for example. I've put there a case study of PE, who's victim of sex trafficking with severe mental health issues, and she was interviewed when she went to report. So the office does this quite often, using kind of reporting event as an opportunity to redocument individuals or ask them questions, or encouraging them to do voluntary return, or sometimes detain them. She became extremely distressed when she was interviewed and suffered from a panic attack. She disassociated and seemed catatonic. So she actually called us during the appointment, but even though she actually speaks English, she was not able to kind of tell us what was happening. She was so upset that after she left, she became suicidal and almost kind of jumped off London Bridge. But fortunately, she was able to kind of get herself to the A&E and obtain help from the NHS. Greater Manchester Immigration Aid Unit also produced a report on the impact of reporting on children and families. So this was only published last year. And again, it's not just the individual. We have a lot of members at Migrants Organized who have children who have to report, and because they don't have any income or financial means to afford childcare, then that means they have to kind of bring their children to reporting events as well, and which means that children also have to queue for hours sometimes. Likewise with electronic tagging, I'm sure this wouldn't be a surprise, but someone who is tagged and kind of monitored all the time, 24/7, there's a lot of kind of detrimental impact on the person's welfare and health. And Bail for Immigration Detainee with Medical Justice and Public Law Project produced another report last year on the impact, which I would encourage everyone to kind of read. I've provided the link in the slides, which will be sent out to everyone after the seminar. So how to challenge bail condition? How do you support someone who is being asked to report, for example, and having issues with them? So the first thing to remember is that challenging bail condition, or what's called asking for a variation of bail condition, is considered immigration advice, which means you have to be accredited in order to do it lawfully. It is a criminal offense to give immigration advice if you're not an accredited advisor. So this has to be either OISC immigration accreditation, or the Law Society, or if you're a solicitor or a barrister. However, saying that, raising safeguarding concerns is not an immigration advice. So especially if you work in statutory services, so if you're a social worker or medical professional, it is definitely within your expertise to comment on welfare issues and raise safeguarding concerns, including with the Home Office. And I think it's usually quite a good way to raise issues about bail conditions without specifically giving immigration advice. And I've put there, even if you're not kind of working in statutory services, always don't, as a general rule of thumb, don't shy away from asserting your expertise, even if you're a charity support worker, an NRM support worker, or personal advisors. It's usually just helpful to have that kind of like objective evidence of someone else saying, there is a concern here, there is a problem with this particular bail condition for this individual for these reasons. Bearing in mind that the bail kind of system, including reporting and electronic tagging, it doesn't kind of exist in a vacuum. There is a policy, Home Office policy, that the Home Office is supposed to follow, namely the immigration bail policy and the reporting and offender management policy. I've put the link there. And obviously these two policies also have to follow kind of higher laws in the system. So that includes like secondary legislations, for example, and of course, acts of parliament, like the Human Rights Act, the Immigration Act itself, Equality Act, and other duties that Home Office is bound to as a statutory, as a public authority. Yeah, I've put there a bit about the difference between an appeal and a judicial review, just to kind of make a point that in order to challenge bail condition, it can only be done via judicial review, and judicial review is slightly different from an appeal. So if someone you're working with has an immigration appeal coming up, for example, that has nothing to do with immigration bail. In order to challenge immigration bail, especially if you're talking from the perspective of someone who is already in the community and not in immigration detention, you have to write to the Home Office and ask them to make a decision about the bail condition, ask them to change the bail condition, the reporting condition, for example, or the tagging condition. And if they refuse, then the way to challenge them is via a judicial review process. So judicial review is a last resort remedy process. So it's something that is available if there's no appeal rights. A judge in a judicial review cannot replace the decision in question. Most of the time, they will just declare that there's a public law error or it's unlawful for different reasons, and ask the kind of decision maker, in this case, the Home Office, to kind of remake the decision, essentially. So when it comes to the judicial review, the strategy is to kind of highlight why the bail condition itself, the one that has been imposed on the person, is either unreasonable or irrational, or it goes against kind of the policies of the Home Office itself, or other duties which the Home Office are bound, again, including Equality Act, for example, duty to consider the best interests of children, etc. Now, I've provided some steps that could potentially be followed when you're assisting someone to challenge their bail and reporting condition. The first step is that, remember, it is immigration advice. And so what you cannot do if you're not an immigration advisor is that you can't write to the Home Office and ask explicitly for them to change a condition or vary it. So you can't act as someone's representative, basically, because in effect, you will be kind of giving immigration advice. But as you can see there in the slide, there's actually a lot of other things that you can do, including first and foremost, providing emotional support for the person. As I mentioned, a reporting condition can be really distressing for a lot of people, sometimes even traumatic. And I think knowing that there's someone else who's paying attention to this issue and offering the support can in itself be really helpful for a lot of people going through this. Find an immigration advisor, helping someone find it. It's really difficult at the moment, but there are kind of charities and organizations that provide immigration advice out there. Google is your friend. You can just Google immigration advice charities in wherever you are based, and start contacting them. Help document this issue that the person is going through. So we'll talk about that a bit more. And as I said, like raise safeguarding concern, referring to public law solicitors for a legal challenge, a judicial review challenge. And obviously you can also help the person contact the Home Office themselves, for example, in just kind of drafting the email or kind of looking through the email that they've drafted themselves. So step 2, forget about kind of the policies and other things that I've mentioned, actually. The first thing to do is actually just to ask the person what the problem is and help the person document that issue. So you don't actually need kind of, legal skills, or even if you don't know anything about the law or the policies, that doesn't really matter, because at the end of the day, what you want to know is, why is this a problem for the person? Why is a specific condition that the person has to do is affecting that person? So details like, how often does the person need to report? Are they tagged on top of being asked to report? How far do the person has to travel, for example? Is it 3 hours or is it just a half an hour ride? How much does it cost? And especially if you're talking about like asylum seekers, in asylum support, they only get about 40 to 45 pounds a week. So using some of that money to travel to the Home Office is obviously not a very good use of their already limited financial support. What are the other issues? Is the person scared, nervous? Is it affecting their mental health, for example, physical health issues? Do they have to queue outside of the reporting center? Do they have children who's affected as well because of the reporting condition of the parents? Do they have kind of studies and other commitments which are affected because of the reporting conditions. So a lot of the things are quite common sense, I would say. Write them down either in kind of bullet forms, or you can also, if you work for an organization, you can also document it more formally using a letterhead, and document like that will be actually really helpful for that person to eventually kind of help them challenge the reporting condition, even if that is all that you can do for that person. For reporting conditions specifically, it's really worth considering whether the person is eligible for telephone reporting. So telephone reporting is something that was introduced during COVID after a lot of pushing with the Home Office. And fortunately, they agreed to adopt it as kind of the standard way of reporting now. So it was introduced last year. At the moment, people who are on reporting conditions should be on what's called a blended reporting approach. So a lot of people should be on telephone or digital reporting. So digital is when they get a link from the Home Office that they have to click to kind of tell the Home Office that they're still around and hasn't absconded. But then occasionally, even individuals on telephone or digital will be called back by the Home Office to like report in person. And the Home Office policy at the moment is really clear that everyone should be on telephone or digital reporting unless they are in one of 5 very specific categories. And these are the 5 categories. So this is a screenshot from the Home Office policy. And the 5 categories are for national offenders, so individuals with criminal records, essentially, people who are engaging with voluntary return, those who have not returned and who have not engaged with voluntary return. I think the implication here is that individuals don't really have anything ongoing, essentially. They don't have any pending applications, for example, and these are individuals that the Home Office think they don't have any right to stay in the UK and are trying to encourage as much as possible to leave the country. So yeah, those identified for removal, where face-to-face reporting is required to facilitate case progression, conclusion, or prompt enforcement action. So things like redocumentation interview, for them to get a travel document to fly back to their country of origin, for example. And lastly, those who are not immediately removable, but have failed to comply with telephone reporting and are currently out of contact. So if you're talking about an asylum seeker who's living in asylum support accommodation, for example, with a pending claim, still waiting for an interview or have done their interview and waiting for a decision, there's really no criminal offense. There's really no reason why that person should be reporting physically. There might be arguments that you can raise to say that the person doesn't need to be on reporting at all, whether digital, telephone, or in person. But at the very least, they should be on telephone or digital reporting, which I think for a lot of people are just much less burdensome than having to travel to the Home Office to report. Step 4, get advice. Again, it is much better because it is part of immigration advice, it is much, much better if the person also have an immigration advisor who is assisting with this, who understands the kind of the substantive immigration case that the person could raise or is raising with the Home Office, because occasionally there might be instances where you need to be a bit careful with what you say to the Home Office, even in the context of immigration bail. So, for example, if someone is claiming asylum based on political grounds and on the basis that the person is a very active politician who goes to, protest all the time and very active in their country of origin, and as a result is being threatened by the government of the country of origin, you probably would want to be careful in terms of then sending Home Office evidence of their vulnerabilities and their mental health or physical health issues, which kind of prevents them from going to report to the Home Office, because then the Home Office might say, oh, you say you go to all these protests and actions in your home country, but then you can't even go report. So that's kind of like just an example of some inconsistency that can arise and need to be kind of thought about, essentially. If the person has an immigration advisor already, so if they're working with a charity, for example, or they have like a solicitor, immigration solicitor who's working with them, ask them. It is part of their job to advise on bail issues, and you can get legal aid to cover this, in theory, at the very least. Now, if the person doesn't have an immigration advisor, it's, the situation becomes urgent and something needs to be done about the reporting condition, then you can contact the Home Office or assist the individual to contact the Home Office. Again, if you're not an immigration advisor, then you can raise it as a safeguarding notice. I've put there a link to, so there are 14 reporting centers in the UK. And if you look at the Bail 201 form of the person, it usually kind of say which is the relevant reporting center. And if you go to that link, you'll see kind of a list of all the email addresses of the different reporting centers. And if you're raising it as a safeguarding notice, I've put there the email address of the asylum safeguarding team. So this only works if the person is in the asylum system. So, if they have a pending claim under human rights, for example, then the asylum safeguarding team wouldn't be able to assist. Remember to assert your expertise, especially if you're a medical professional or a social worker. Say that in your letter, kind of say, this is, I've been working with that person, with the person for a long time. I know their conditions. These are why things are difficult for them. I'm really concerned about this current condition. Please assist. Or, as I said, you can also have the person contact themselves. So sometimes you can just, give the person information and they might be able to draft the email on their own, for example. You can just grammar check the emails. And yeah, you don't actually have to represent the person, basically. A good strategy, as I said, might be simply to ask for telephone reporting, because the categories of individuals who are supposed to be on telephone reporting are very specific. And there might be other kind of like fancier things that you can ask the Home Office to do, but as a baseline, I think a lot of people should be on telephone reporting, and you can just say to the Home Office, could you please consider whether this person should be on telephone reporting because they're struggling with the current one, and leave it at that. Document everything, so keep all the emails, the letters, whatever. If you call the Home Office, then note it afterwards immediately, have a note on it, and give a deadline for the Home Office to reply, because they don't always reply. So as a rule of thumb, I would say, first letter, give them 7 working days. If they don't reply, second letter, give 3 working days. And then if that deadline has passed, that actually, you can then find a public law solicitor to help challenge via judicial review proceeding. Remember, there is always that chance of, if you contact the Home Office about reporting condition and raising issues about it, it might highlight the person's case more than would be good for the person. So especially if we're talking about someone who doesn't really have anything pending, for example, or something is pending but it's really weak, and don't have an immigration advisor or solicitor representing the person, then there is a bit of a risk that if you highlight that person's bail condition too much and kind of annoy the Home Office too much, they might look at the case and then actually proceed with further enforcement actions against the person. But, as a general rule of thumb, if the person is an asylum seeker with pending claim, waiting for an interview or waiting for a decision, then the risk, I would say, is really, really low. And in any case, I think highlighting the case to the Home Office might actually just be better for the person, because it would mean the Home Office actually progressing the case. Same goes if the person is in the National Referral Mechanism system, so victim of trafficking who has reasonable grounds decision and waiting for conclusive grounds, for instance. Note, of course, that this might change if the legal immigration bill is enacted and implemented. There might be kind of other considerations to think about, even if you're an asylum seeker, because then regardless, the person might just be detained and the Home Office might try to remove them to countries like Rwanda, for example. We have much more detailed guidance on how to assist individuals to challenge their reporting conditions, aimed at advisors and caseworkers and support workers. This one, October 2022, is out of date now, but we're going to update it next week, actually. So watch out on, check our Twitter and Migrants Organized website, because we'll upload it there. And it has much more kind of detailed step-by-step guide on how to challenge reporting condition. and join our campaign. So we've got an abolish reporting campaign to challenge reporting conditions and electronic conditions as well, and all forms of government surveillance on migrants and asylum seekers. And if you're interested to join, please feel free to contact me. Yeah, so that's the end of my spiel. Went through it quite quickly. But yeah, does anyone have any questions?
Brian, there's a question for you in the Q&A box.
So question from Vidya, given the shift to make seeking asylum illegal for those arriving via unsafe routes, will this mean everyone will be tagged? Yeah, I think there's definitely, I mean, Priti Patel was talking about all asylum, tagging all asylum seekers. I think there's a bit of a problem practically with the Home Office tagging people as well, because I think at the moment, even individuals with criminal convictions, they haven't managed to tag everyone because there's not enough tagged. They haven't been able to kind of resource all the tags that are necessary, even for current provision, essentially. Yeah, I think it kind of depends on how the illegal immigration bill pans out, because at the moment it's still in the parliamentary stages and it's passing through parliament. It needs to, we need to see what it actually says when it's enacted and when exactly it's going to be implemented. Because a lot of the times, if you see the Nationality and Borders Act 2022, a lot of provisions there are not enacted yet, for example. There's a lot of horrible things there as well, but if it's not implemented yet, then it just kind of stays in the books, basically, and nothing sort of happens. So yeah, but there is always that risk of everyone becoming criminalized, and then therefore the Home Secretary has a duty to tag them. Right. Does anyone have any other questions? I hope those are clear, or kind of any cases that you're encountering now. We could have a quick discussions on it. Yeah. Another question, could I ask to hear a bit more about what the GPS tags do, what information is sent, and to who, for what purposes, etc. So I would really encourage you to read this report, because it kind of like talks about it in quite a lot of details. But essentially, the problem with the electronic tags at the moment is that it's not radio tag anymore, it's GPS, which means the Home Office gets kind of minute by minute data of the person's whereabouts. So it's basically the same as your phone with Google Maps. It's very accurate and it's very specific. And yeah, it's just it sends all the data to the Home Office, essentially. And I think the Home Office has talked about using those data to make substantive decisions as well. So for example, you can imagine if someone is claiming asylum on the basis that they're LGBT, the Home Office might ask, oh, we see your tagging data and you don't go to places like Soho or, where LGBT bars are, and might therefore question your credibility in terms of your assertion that you're LGBT. That sounds quite far-fetched, but to be honest, I've read kind of Home Office decisions which say that the person is not LGBT because they can't name a single kind of gay bar in Camden or Soho, for example. And it's the same with if someone has an application based on their relationship with children, for example, with their family. The Home Office might say, oh, you say your child lives with the mother in this place, but I don't see from your GPS tags that you've been going there. So you're lying about your relationship with your child. So those things. But I mean, technically, it is supposed to be for bail condition purposes. The tagging data is supposed to be kind of a way for Home Office to check where people are and making sure that they don't abscond. Which, if you think about it, is a bit illogical because the absconding rate is already really low, and there's really no evidence that tagging actually encourage people to stay more in touch with the Home Office. Because if someone is already tagged, it's already been through the system, has already an application put in, then by definition, these are individuals that do want to be interacting with the Home Office and do want to try to get their immigration issues resolved. If they wanted to kind of abscond, they would have absconded in the first place. Cool. yeah, I think if there's no more question, maybe we can just end there. And I'll let everyone enjoy the nice weather. But yeah, if there's any questions or things like that about reporting or bail condition, feel free to email me. And as I said, everyone will be getting the slides as well, which will be sent out to everyone this week. Great. Okay. Well, thank you so much, everyone. Hope you found that helpful.